5 seconds to go. Start. Further, assessee markets the agricultural produce of its members. It retains the sale proceeds in many cases. It is this retained amount which was payable to its members from whom produce was bought, which was invested in short term deposits or securities. Such an amount which was retained by the assessee society was a liability, and it was shown in the balance sheet on the liability side. Therefore, to that extent, such interest income cannot be said to be attributable either to the activity mentioned in section 80p2 of the Act. Therefore, looking to the facts and circumstances of the case, the assessing officer was right in taxing the said interest income under section 56 of the Act. To say that the source of income is not relevant for deciding the applicability of section 80p of the Act would not be correct, because weightage needs be given to the words the whole of the amount of profits and gains of business attributable to one of the activities specified in section 80p 2a of the Act. The words the whole of the amount of profits and gains of business emphasize that the income in respect of which deduction is sought must constitute the operational income and note the other income which accrues to the society. As regards validity of the notice under section 148 of the Act to reopen the assessment, it essentially concerns factual aspect. The tribunal is the final fact-finding authority under the Act. It has given a finding of fact that though the written communication of the sanction, which has no prescribed format, was received by the assessing officer on 8th June 2001, but the approval or sanction for reopening of assessment in terms of section 148 of the Act, read with section 151, existed even prior to 31st May 2001. There is no reason to interfere with this finding of fact given by the tribunal. In the instant matter, the question whether on the facts and in the circumstances of the case the tribunal was right in law in holding that the income by way of interest on deposits held with scheduled banks, bonds, and other securities was chargeable to tax under section 56 under the head income from other sources without allowing any deduction in respect of cost of funds. Pursuant to the aforesaid order, the respondent has filed an additional counter affidavit in which he has emphasized the desirability of remanding the matter back to the disciplinary authority for redetermination of the matter. He has emphasized that failure to supply the inquiry report to the delinquent deprives him of making a proper representation to the disciplinary authority before that authority arrives at its own findings with regard to the guilt or otherwise of an employee. This admittedly not having been done, clearly the respondent was prejudiced in submitting his defense. Even if this court concludes not to remand the matter back to the disciplinary authority, at least it has to be remanded back to the High Court. He had stated that a number of points were raised before the High Court which have not been considered on merits, as the High Court decided the writ petition only on the ground of non-furnishing of the inquiry report. Since the inquiry officer and the disciplinary authority had concluded that some of the charges have been partially proved and others completely proved, it was necessary to supply the findings of the inquiry reports. Only on knowing the reasoning of the inquiry officer could the respondent give an effective explanation. It is further pointed out that with regard to the charges relating to Maharajganj, the entire amount has been recovered. This fact is noticed by the disciplinary authority, but quite illegally it still proceeded to impose punishment on the ground of proved misconduct, since the disciplinary authority arrived at the decision on the basis of charges which were partially completely proved. It was not possible to defend during personal hearings. According to the respondent, this was stated by him at the personal hearing, but it was ignored. In fact, the disciplinary authority was adamant to punish the respondent. All these issues could have been highlighted if the High Court had decided the writ petition on merits. Therefore, matter needs to be remanded back to the High Court for a decision on merits on all the issues raised by the respondent. In our opinion, the aforesaid grievances of the respondent are without any factual basis. The petitioner has placed on the record of this court the translated copy of the charge sheet, reply of the respondent to the charge sheet. Stop.